and saying, well, that cannot be the case. We're talking about Godfred Dame. Yeah, but the fact that our own colleague, that's Joseph Akable, interviewed him, will bring you that particular interview. But in the midst of all the controversy, we ask that simple question. What did the Supreme Court say? I know there are many of you who've actually, sent us messages and you've talked about what does it really mean? Well, I do not pretend to be a lawyer. There's one thing I can assure you. The fact that I would ask all the questions that you need and ensure that we get all the answers that would get you to understand what this really means. Is it an indication that the Electoral Commission can go ahead and compile a new voters register? Well, that's what the Electoral Commission thinks, and I'm sure by now there's a bit of clarity, isn't it? Well, the EC says they're going to go ahead and compile the new voters register. So when we return after this break, I'll be joined by a private legal practitioner. He has studied the document. He has studied the relief that the NDC sought from the Supreme Court. He's also looked at the ruling of the Supreme Court in a unanimous decision, and then help us understand. I know you wouldn't want to miss any bit of this conversation. My name is Winston Amwa, and when we return after the break, we get into the deliberations, we get into understanding what the Supreme Court ruling means for the compilation of a new voters register. We'll be right back after the break. All right, so welcome back from that short break, and thank you very much for staying with us. This is UPfront on Joynews channel. My name is Winston Amwa, and this evening we've been joined by private legal practitioner Martin Kpebu. He'll be helping us understand what the ruling of the Supreme Court means, but also in the course of the program, Joseph Akable, who is our court correspondent, spoke with Deputy Attorney General Godfred Dame, and we'll bring you that interview also this evening on UPfront. But let me get straight to Martin Kpebu, who's joined us on phone with one or two issues. Martin, good evening. Thank you very much for joining us. Hello, Martin.
Yes, I can hear you.
Great. Thank you very much for joining us. So there's been lots of, conversation, and lots of controversies, debates, if you could put it that way, about what the Supreme Court says in its ruling this morning. I know you've looked at it with your legal, understanding. What does the Supreme Court, in a nutshell, say in its ruling this morning?
Okay, so, for instance, it's a case that the Supreme Court says that the old voters' ID card cannot be used. The old voters' ID card cannot be used.
Martin, if you could kindly reposition yourself, your volume, your sound isn't so clear, your audio isn't so clear. If you could kindly reposition yourself.
Let me see. Is it better?
Yes, I think so.
Yeah, so I said the Supreme Court decision is to reflect that the old voters' ID card cannot be used in the impending EC registration. Yes, so that to get that sense, you look at from release 5, 6, 7, and 8 of the NDC rate.
Okay.
And I think so, I'm sad because I was strongly in favor of the old voters' ID card being used, but it turned out that the court doesn't think so. It's the Supreme Court that decides. So apart from that, then...
Okay, so Martin, kindly hold on. Would have to get back to you. Would have to try and get back to you because I think that your line is giving us a bit of a challenge. But all that Martin Kpebu was saying that when he looks at the ruling of the Supreme Court, to him, his understanding is that you cannot use the old voter's ID card. Well, what that means actually, the current voter's ID card, because we now have a voter's ID card. But in effect, he says what we currently have as a voter's ID card cannot be used in the registration for the voter's ID card for election 2020. Now, the Supreme Court says that the Electoral Commission can go ahead and compile a new voters register. Yeah, so I think that Martin is back. Yeah, Martin. Hello, Martin Kpebu. Hello, Martin.
Yes, I can hear you.
It is better now. Yes, you're making a point. Go ahead.
Yes, I'm saying that sadly, the Supreme Court has decided that the old voters' ID card cannot be used in the impending registration. Yes, and to understand that when you read from the release 5, 6, 7, and 8, that's where specifically the NDC mentioned that they want an existing voter ID card to be used. And the court said no. So there is a certain part that somehow, or for lack of a better word, some see as a source of confusion. That is, if you look at the Relief 2 and 3. In Relief 2, essentially the NDC thought that the right to vote should be protected. And the court said, yes, the right to vote should be protected, but subject to CI 26. So subject to CI 26, it means that it's when you have gone through CI 26 that your right should be voted and should be protected. Then Relief 3 also says that a person who is registered has an accrued right to vote. Yes, and the court said, yes, we agree, but that is when you have gone through CI 126.
Yes.
The CI 126, when you've gone through it, that is, if you have been registered pursuant to that CI 126. So it looks like the initial, I mean, we're seeing it as a big confusion initially, but it looks like when you read it over and over, the confusion seems to disappear. Well, maybe some of us is because we're hugely disappointed. That's why the confusion.
So we would come to your disappointment, but I mean, we've had lawyers, I heard Alhaji Nusa Fuseni, who was Member of Parliament for Tamale Central, also explaining, I've heard others say that, well, no party can claim victory. Is the confusion the fact that, Relief 2 says declaration that the AC's power to compile and review register must respect and protect the right to vote? In there, what is your understanding of it? If it must protect the right to vote, doesn't it include the fact that nobody should stand the chance of being disenfranchised?
Yes, reading it by itself, Winston, you are perfectly right. But when you now go down to the Release 5, 6, 7, and 8, that is where specifically NDC pleaded that somebody who has an existing voter's ID card has a right to vote. And the court says no. They say somebody, if the EC attempts to, you see, it's not just one relief. You see the 5, 6, 7, and 8,
yes.
They are very related. They say, well, now they say different angles, okay? Then they say if the EC disqualifies somebody who has an existing voter's ID card, it is unconstitutional. Then the court said no. Maybe because you have it before you, you can read the various renditions, about 3, 4 different renditions on the old voter's ID card. And all of them, the court said no, no, no. So it appears, Charlie, but it's not over. Don't forget, the corona scare is still around and the weather and all that. So it doesn't mean that by all means you should compile a register. No. It's still up to EC to listen to our plea.
Well, the EC has issued a statement in which it says that it's going to go ahead and compile the register. But you say, sadly, now that the ruling is out, at least you can say, what you disagree about the ruling. When you say sadly, what is your disagreement with it? Why do you think that the old voters register should have been part of it at all costs?
It stems from Abu Ramadan. You see, from Abu Ramadan, those series of cases, this register had been the subject of the Abu Ramadan decision. When the court looked at it, I said, look, okay, the part that the case had been made, that the NIA registrants should be removed. So what I mean is that if the court has previously looked at this register and helped to clean it up, we shouldn't turn around in just a few years and say, no, we are not satisfied. This register is so bloated. No. The court is, look, you see this argument, there are dead people on the register, there are foreigners. All these arguments were made in 2016. And yet the court said, look, we will only delete those who registered with the NIA card. You see, the National Health Insurance card. Okay, those are the persons to be deleted. So it means that the court has really looked at it. The court accepts that no register can be 100% perfect. If human beings are not 100% perfect, how can their product be 100% perfect? You see, elections are not about getting a 100% bill. No. We all accept that being human will get it wrong at one point or another. Besides, Winston, why did this current EC sit down all these years only to come in 6 months to the election? That's when they want to compile a new register, especially in this corona era. So for me, really, I don't see myself going out to register. That one, they know this year, if the EC doesn't allow those of us who are already on the old register to vote in December, then this year, well, I'm not going to vote.
You will not register?
No. Oh, that one is out. I don't intend to go and stand in the queue to register. There's no way.
Why? What's wrong with registering? It's your civic right to vote.
Yes, and the Constitution exalts us to. Look, these are very challenging times. Why don't we maintain the old register? Let's get through this corona. Then subsequently, we can take our time, perfect, improve the system. Definitely, it won't be 100% perfect. We always have problems. But then we can take our time subsequently and do a good job. This one is going to be a rush job. Listen, when people are going to register for elections, register. People go and sleep at the registration centers. People go with stones and all that. And there's bound to be contact. This is the very thing that we're trying to avoid now, the social distancing. It's going to be highly difficult to observe the social distancing at the centers. But we say no, it doesn't bode well for us.
No, but these are the reason why the NDC goes to court. The Supreme Court has looked at it. It has looked at it and realized that there's absolutely no justification to prevent the Electoral Commission from going to register. Legally, there's nothing wrong with it. So why don't you allow the Electoral Commission to do what is expected of them? And you also get to ensure the fulfillment of your civic right by going to register and vote.
Winston, you are perfectly right. You see, the operative word is that legally. But don't forget that when you live in a society, it's not only the laws, but you also consider the psychology of the people, the health and safety needs, the financial needs, and everything. So the legal angle is just one angle. So now how about health and safety at this time of corona? And the economic angle, very good, I'm back here. Listen, from the calculations, it appears we're going to spend a lot of money from the new system. It's stopping over 100 million, isn't it?
It's about $440 million.
Dollars.
No, Ghana cedis to compile the new register.
Yes, Ghana, yes. So then that's about $100 million minimum. Okay. So this is money that we could better use to help in our corona fight. A few days ago, didn't I hear that they had only 8 corona beds, right?
Yes.
And the work on the 44 project had stalled. So let's take care of our health and safety first. And then let's manage. And the EC, when you go through the material available online, there was even one ahead, Mr. Sribuokwaku. He said if they are not able to compile a new register, they can manage with the old one. Let's manage. Winston, is it every time that when you buy a set, when you have a set, don't you wear for years? I have sets that are sometimes even 5 years old. We still wear them.
Sure.
Let's manage. Why is it that when it comes to elections, often as soon as we use a register for one election, the next moment they want a new register? This is what the parties have been taking us through. It's about time we stop. Let's spend the money on the corona fight. Let's manage this register. Look, if people are scared about foreigners coming in, you remember the MPP in opposition, Kennedy Japan said he and his men were able to stop the Togolese and those people from coming in.
Yes.
So now that the MPP is in power, they can station the military at the borders and all the unapproved routes. They can prevent the foreigners from coming in. It will cost far less. Right now, my fear is that this registration, we are just going to expose ourselves to the corona. I don't think it's worth that risk. When I know that the old voters register can be managed.
Good. So you make a point that maybe the Supreme Court should have looked at other things, but you're a lawyer. I mean, in ruling, and I use legally again, in ruling, once the party goes to court with a true and proper interpretation of the Constitution, why should the Supreme Court look at the times we're in when what is in front of it is a proper interpretation of the law?
Okay, Winston, I'm happy you've asked the question so that there will be no doubt.
Yes.
No, when I was talking about the other angles, I wasn't referring to the court.
Okay.
No, I said, as on legal grounds, my laws have held. That one, who am I? Not much that you can say about the decision over there. But we're hoping that, in sociological jurisprudence, looking at the mood of the country, the way the corona and all that, they could have. But, well, they say they deal with laws, but not with other social matters that are not before them. So I was specifically referring to the EC, that though they've won in court, it doesn't mean that they should, by all means, compile a register. No, they should be magnanimous. It's possible for the EC to go into conclave, come back and say, you know what, Ghanaians, yes, so we won handsomely in court. We are there magnanimous. We will do our best to use the old voters register. And then next year, when times are better, we can compile a fresh one. So is the EC I'm calling upon to be magnanimous in victory. Yes, they've won, but it's within their power. Remember, it's their discretion. They can look at the current COVID-19 situation in the country and the fact that the ECOWAS protocol say that in an election year, don't take major decisions. Election bodies should not take major decisions. They should listen to the cry of our chiefs, so Nanano, National House of Chiefs. They should listen to the 100 university professors, the people who taught us that we can earn our daily bread. These are no mean people, though. You can never finish thanking your teacher for what he taught you. All these people, the medical doctors. Yesterday, I hear that a group of doctors who had and health workers have come together. So we are asking the EC, yes, they've won, but they should be magnanimous in victory. They can turn around and say, okay, they will just hold on with the new one, and they will manage with the old one, and we'll applaud them.
Now, the Supreme Court ruled in a unanimous decision. I mean, were you surprised that there was no dissenting view in all of this?
Yes. Oh, definitely. Because looking at the Abu Ramadan decision saying that the existing voters card is prima facie evidence of a person's eligibility to vote. Yes, based upon it, yes, an unanimous decision is quite surprising.
You were expecting some of the judges to dissent and say, we do not like this. But doesn't that also tell you that the judges believe that, they believe the argument of the Electoral Commission that the current register is the fruit of a poisoned tree?
No, not necessarily so. Until I see that, when the full judgment is made available, until I see them quoting it and saying that is what they approve, I'm not able to say that that is what the court was approving.
Well, we'll wrap it up shortly so that we bring the interview that we had with Godfred Dame-Yeboah. But there are instances where people, receive judgments. But I'm sure that when you have a unanimous verdict like this, seeking a review is unnecessary, is it?
Yes, you have a point. But when people are hurt, sometimes they just want to be very clear. Yes, so it's for the NDC to look at it and decide. Yeah, but it appears it's very clear that the court doesn't want the existing voters' ID card to form part of the new register. So it's like starting on a clean sheet. Okay.
And you are not willing to go and register. What would make you change your mind and go and register?
Nothing. I intend to show up on the voting day on September 7th, yes, in the hope that maybe when, listen, look, mark it on the wall. Listen, what you call it? The public turnout is going to be low. There are millions of Ghanaians who are scared. Millions are scared, so they turn out to be low. So what I'm foreseeing is that after all is said and done, the EC will come back and say, okay, they will open a window of opportunity for people on the old register to come and vote. And that will be the right thing to do.
But that will be contrary to CI 126, because CI 126 makes it very clear. It says that these are the requirements, or these are the documents you must have in order to register. It doesn't talk about, the current voters register. It says a passport, a Ghana card, and you fill a form where you'd have, 2 persons who are already registered vouching for you that you're Ghanaian, and then you go ahead and register.
Winston, correct me if I'm wrong, but it doesn't appear CI1 says that the old voters register is void. I don't think it mentions.
CI 126 talks in talking about the documents that one can use. So you can register subject to the provision of these documents. And the documents that it says you should use has, the passport, the Ghanaian passport, Ghana card, and 2 persons who are already registered vouching for you after the filling of a form. So it doesn't talk about the current voters register. What it means then is that you can't use it to register, doesn't it?
Oh, not a register. So I want to remain that the old voters register on the election day be maintained so that there will be a window of opportunity for those who are on the old register. Remember, I think in one of the elections, is it 2012 or so, there was something like that. Is that not true? Yes, you are good at this history.
In 2012, what actually happened was that elections were held on 2 days. So in the first instance, on the 7th, people couldn't vote, so they were giving a chance to vote on the 8th of December. But in 2012, we compiled a totally new register. That was the much talked about, much publicized biometric voters register. So, prior to that, we had a register in 2004, which was amended, through the limited registration exercise. So that's what we have used all this while. And then we had one in 95, another one in which we also amended in 96 by a limited registration exercise. So, the voters registers in this country have had a life cycle of 8 years. So you do 8 years, then there's a change, there's a new one. But in all of them, if you go there, for instance, and showed your existing voters register, you are taking through the process. That is not going to happen this time.
Yeah, so we're praying that the EC should be magnanimous. Magnanimous in victory. Please do something about those of us who are unable to come out to register so that we are not disenfranchised. No. The EC is within its mandate to do so. Nobody has said that the old voters register is totally void. No, it can be used for certain purposes, including opening the window for those who are on it and who are not able to register to come and register. Because when the market, I've told you, turnout will be low. Yeah, it won't be as encouraging. Because what is the need that you want to risk coming into the corona? No, my brother. You wait. Yeah.
All right, Martin Kpebu, you want the Electoral Commission to actually look at the fact that, yes, even though they've won, they still should not go ahead and compile a new register because of, coronavirus. Sadly, the Electoral Commission has come out to say that they're going ahead on the 30th of June. So thank you very much, Martin Kpebu, for joining us. We're grateful you made time to join us this evening. Do have a lovely evening. Enjoy the rest of your evening. We'll go for a short break. When we return, we'll bring you that interview that Joseph Akable, our court correspondent, had with Godfred Dame. We'll be right back. All right, so welcome back from that short break, and thank you very much for staying. This is Upfront on Joynews channel. My name is Winston Amma. So before the break, I talked about going for that interview that Joseph Akable, our court correspondent, had with the Deputy Attorney General Godfred Dame. We'll go for it now, and there'll be more after this particular interview.
Following the consolidation of the cases, your position was that the current register could not be used. The court essentially agreed with you. Your initial reaction to the decision of the court?
I think it's very welcome. For me, it can only advance democracy in the country in the sense that the very sense of democracy is the protection of the right to vote, and the right to the people to elect their representatives, to elect their president, in accordance with the hallowed principle of one man, one vote. And I sought to indicate at the last agenda that indeed the voters register has been shown to be over-bloated. And it has been so since 2012, and it was so again in 2016. It was also, it is so presently. So it has been so since 2012. And if you look at 2012, the declaration of results, the number of registered voters, as declared by the Electoral Commission, was about 14.1 million people. But the total number of Ghanaians over 18 years was, as per the statistics of the Ghana Statistical Service, 13.7 million. So the very obvious question one ought to ask is, how can the number of Ghanaians aged 18 and above, who I consider to be the registrable population, be less than the number of total number of registered voters? That is incongruous. It cannot be. And the same pertained in 2016. The number of registered voters was about 15.7. Yet, Statistical Service indicates that the total number of Ghanaians aged 18 and above is about 15.2 million. And you remember that the NDC also was making the point in court that there is supposed to be about 18 million people on the voters register. That was unsubstantiated and totally baseless, because the evidence for the Statistical Service, which I furnished the court, indicates that the total number of Ghanaians aged 18 and above is 16.6 million people. So where from that figure? They just threw it up in the air without backing it up with evidence, and that's what the people of Ghana were made to believe. And so I think that the court ruling is very good. It protects the right of the Ghanaian to vote, in the sense that it shows that clearly it is intended to ensure that only Ghanaians who are qualified to vote indeed register to vote.
In terms of the ratio of the court, it affirmed the independence of the EC once it's not acting contrary to law, and again gave orders as to compiling the register in accordance with CI 126. I'm sure you have seen what the NDC's General Secretary has been saying. Are you surprised with the interpretation that has been put on the decision of the court, and what is the AG's position on the decision of the court? I'm
totally amazed at the ridiculous interpretation that has been placed on the court ruling by the NDC, especially NDC's General Secretary. I mean, clearly, it's only a person who perhaps did not have an understanding of what the court said today who could make such a conclusion. It is quite clear. They have the ruling of the court before me, and you have to just match it against the specific reliefs that were sought by the NDC. And you see that clearly in terms of the substantive reliefs, they're all dismissed. The substantive reliefs were relief 4, which was a declaration that upon a true and proper interpretation of the provisions of the Constitution, particularly Article 42 of the Constitution, all existing voter ID cards duly issued by the second defendant, the Electoral Commission, to registered voters are valid. That's the NDC's claim. Now, what did the court say? The court stated relief 4 dismissed. Relief 4 was dismissed categorically and expressly. Then you move on to relief 5, which was also one of the reliefs bordering on the use of the voter ID card to register. It says a declaration that upon a true and proper interpretation of the Constitution, specifically Article 42, the second defendant's purported amendment to Regulation 1. That is the new regulation that NDC was complaining about, Regulation 1, Sub-Regulation 3 of CI 91, through the Public Elections Registration of Voters Regulations 2020, to exclude voter ID cards as proof of identification to enable a person to apply for registration as a voter is unconstitutional. Same was also dismissed by the court. Relief 5 dismissed. Then relief 6, a declaration that the second defendant in purporting to exercise his powers pursuant to Article 51 of the Constitution to exclude the existing voter ID cards from the document required as proof of identification to enable a person register as a voter without any justification is arbitrary. Same was also dismissed. Relief 6 is dismissed. Then the court proceeded to reiterate their decisions in the Approval Ramadan number 2, that indeed where the Electoral Commission has a discretion to exercise and there are options available to it, no person can question any choice that the Electoral Commission makes. And the court proceeded again to dismiss relief 7. Relief 7 was that a declaration that upon a true and proper interpretation of the Constitution, especially Article 42, proof of identification for registration as a voter should not be limited by the provisions of the Public Elections Registration of Voters Amendment Regulations. Again, same was dismissed, and they said subject to CI 126. CI 126 is what has been enacted by the Electoral Commission. So clearly, all the substantive relief sought by the NDC were categorically and expressly dismissed. There's no ambiguity at all. If there's any lack of clarity, perhaps lack of clarity only emanates from the poor understanding of some sections of the NDC who were in court today.
And in terms of the jubilation that they engaged in, which was obviously problematic, it started from the bit about the 2 reliefs that were granted. The first that made the point that, you have the right to vote and it cannot be taken from you capriciously. And the second being that it accrues to you once you are issued with a card. As some interpret that to mean that it will mean that we have to make some amendments to CI 126 since those people have already been issued with cards and it has accrued to them. That is
Totally ludicrous and legally untenable. Indeed, there are 2 reliefs that were granted by the court. As far as I'm concerned, amounted to mere commentary on the provisions of the Constitution. The 2 reliefs did not add anything at all to the NDC case at all. They were a clear statement of what the Constitution itself has stated. Because if you seek a relief that a declaration upon a true and proper interpretation of the Constitution, specifically Article 51, read conjointly with Article 42 of the Constitution, the power of the second defendant to compile and review the voters' register must be exercised subject to respect for the right to vote. What have we sought? Nothing at all. We are only stating what the Constitution impliedly and explicitly states, that indeed the right to vote must be respected. Yes, the court is granted. So what? It's empty. It's nothing. Then you go to the other relief that was granted. A declaration that upon a true and proper interpretation of the provisions of the Constitution, particularly Article 42, upon registration of an issuance of voter identification card to a person, that person has an accrued right to vote, which cannot be divested in an arbitrary and capricious manner. Again, that's what the Constitution implies and expects. And what did the court say? Relief 3, So the court stated that relief 3, the relief is granted subject to the voter registration card issued to an eligible voter under the prevailing constitutional instrument CI 126. So it says clearly that yes, we even agree with your contentions, which is, as I indicated, what the Constitution expects and implies. But it says subject to the new regulation CI 126. So the NDC went to court, they had their faces badly bruised, and that is it. I think they ought to face the music. They ought not to play any tricks on the minds of the people. All the statements by the General Secretary were totally misleading and unwarranted. And for me, it is most deplorable because he's actually seeking to scandalize the court. You cannot go and then make or deliberately misinterpret what the court said when you were there. And clearly you can read.
Do you agree that the court should take a serious view to that kind of commentary?
These are things that, I would not even pursue, ignore it. I think that people do not take him seriously, and I do not think that it should be taken seriously. Clearly, it is what he said is rebutted by the plain words of the court's ruling, set out in black and white on paper.
The other case also, which was the Techibansin one, that one had a number of reliefs, about 8 of them, also introducing new elements, including the birth certificate as well.
Good. So the denial of all the reliefs in the Techibansin case reinforces the point that indeed the NDC's reliefs were substantively and essentially dismissed. Why do I say so? Because the Techibansin case had clear reliefs. Those, as far as I'm concerned, were even reliefs that properly ought to be filed, because the lawyer in that case went straight to the point, unlike the lawyer for the NDC who sought to make commentary on provisions of the Constitution, a declaration that if you deny a person's right to vote is unconstitutional. There's something that everybody knows to answer. But the Techibansin case explicitly sought a declaration that the use of the old ID card was unconstitutional, and also proceeded to say that the use of the birth certificate, a denial of the use of the birth certificate was also unconstitutional. And the court dismissed all the reliefs. So how could the NDC jubilate on account of the fact that, on account of an allegation that their reliefs had been granted, and the same court would dismiss all the reliefs that were sought by Techibansin? So for me, even the dismissal of the entire relief sought by Techibansin clearly throws light on the point that all the substantive reliefs that were sought by the NDC, which were essentially the same as Techibansin, were also dismissed. At least one not in that at all. So birth certificate cannot be used. The old voter ID card cannot be used. That's the effect of it. And the Supreme Court proceeded to actually admonish Ghanaians to comply with the regulations that had been enacted by the Electoral Commission. The Supreme Court made consequential orders and says, in exercise of the powers conferred on us under Article 2 of the Constitution, we hereby make the following orders. And orders made by the Supreme Court under Article 2, Clause 2 of the Constitution are binding on all and they have to be complied with. No person can elect to disobey these orders. The Supreme Court enjoined all of us, says it is hereby ordered that all stakeholders and the Ghanaian eligible voters are directed to comply with Articles 42 and 45 of the Constitution and the Public Elections Regulations CI 126, as regulated by the Electoral Commission, i.e. the second defendant in so-and-so suit and the first defendant in so-and-so suit, and carry the constitutional mandate to compilation for a new register. So the Supreme Court, out of abundance of caution, ordered all Ghanaians and all stakeholders to ensure that they comply with CI 126. Then, lastly, the court also made an order prohibiting the continuance of all suits pending at that court. You will recall that there had been some other suit filed in the High Court. The Supreme Court, in exercise of its powers as the highest court of the land, made an order totally prohibiting the continuation or continuance of those suits. So all those suits are stayed permanently and forever. This is the final judgment of the court on the issue in question, and it must be complied with.
I thought it was more of asking them to abide by that directive, especially with that application, because you know that is for a judicial review that has been filed at the High Court by the Ashaman MP and Esnogbe.
Yes, so it says by this decision, the Electoral Commission, second defendant, is hereby directed to commence the compilation with registration as scheduled. Then by these decisions as well, they proceeded that any court in which same or similar action is pending or yet to be filed shall apply the decision rendered by the Supreme Court in these cases. So no court has the option of electing whether to comply or obey this ruling. The Supreme Court has ordered in the exercise of its powers over all lower courts in the country that this decision is a final decision on the matter and must be complied with by the court.
We know they had filed for an injunction which they are supposed to move on Monday. So it means that Monday they will have to go for that. You have to go and argue that injunction before the court and ask them to abide by the decision of the Apex Court, or it operates automatically. They are not going to have a hearing at all.
No, so this decision will be brought to the attention of the High Court, and the High Court will make an order accordingly, dismissing, in essence, all the reliefs sought. For all the reliefs sought are also in the nature of the reliefs that, or similar to the reliefs that were being claimed in the Supreme Court. So the court will not have to hear an injunction and then come back and hear the substantive suit. The presiding judge would definitely, in accordance with this ruling, proceed to issue the necessary orders, which will be on all fours as the instant action.
But going for a judicial review, is it not fair that they allow the courts to just take a look at the process leading to the decision to compile the register, which is what normally judicial review looks at, as against the interpretation and enforcement which has been carried out by the Supreme Court? Now,
the Supreme Court under Article 129 of the Constitution has the power to exercise all powers vested in any court at all. That we call it the residual jurisdiction, the residual power of the Supreme Court. They can exercise all powers that are lawfully vested in any court or tribunal in the country. So the Supreme Court, in exercise of the powers conferred on it by the Constitution under Article 129, has made its consequential orders, and all courts are supposed to comply. I think the essence is quite clear that there ought to be order in the administration of justice. There cannot be a situation where the Supreme Court has taken its time to adjudicate on this matter, made orders which are binding on the NDC and all citizens, and then another citizen will be prosecuting another matter in the lower court. So for the sake of ensuring order and an efficient administration of justice, the Supreme Court has exercised its powers under Article 129 and made these orders, and all courts will be required to comply.
One thing that came up in the course of this proceeding has to do with the amicus application. You had argued that they were coming in not to add anything new to the court. Do you think, per what the court has concluded, that indeed looking back at the brief that they had intended to submit, the court would have determined differently if it had allowed that amicus to go in?
Oh, definitely not. I mean, I took a very serious look at the amicus brief because indeed I realized that they had sought to attack the submissions that I had filed. And so indeed, when the lawyer got up in court to say that he had not read the submissions, the first point I made was to point out to the court that he was not being candid to the court. So first and foremost, you find a person who is not a party to the case coming into by way of a third-party intervention, who is not even candid with the court. I think that is very deplorable. So, and then you see that in his submissions, virtually, what was he bringing? Nothing at all, but just the same as the submissions that had been filed by the NDC and Techibansen. So really, all he was seeking to do is to make multiplicity of arguments in respect to the same issue, and that is nothing new. Even if you look at the value of the amicus brief, I made the point that there are only two cases that were cited in the amicus brief. There's a common law tradition, there's a tradition that thrives on the passage of statutes and the decisions made by superior courts of judicature. Indeed, there's specifically subject matter an issue. There are many cases that could be referred to. The amicus brief had only two cases, as a matter of fact, and those were the Abu Ramadan case as well as the election petition case, which had all been examined. Then also, you would notice that the amicus, if you examine further, you realize that even the basis on which they were coming were even flawed. The amicus indicated that the number of foreigners in Ghana was 350,000. That clearly was wrong, because it flew in the face of the evidence that I had presented to the court by the statistical service, showing that as of now, June 2020, there are about 800,000 foreigners in Ghana. So really, what are they bringing? So the factual basis on which they were coming were flawed. The legal bases were empty and hollow, and therefore they're not going to add anything new. All the points we're seeking to argue had already been canvassed by the parties in the matter. And I think in the interest of expediting, I think that perhaps one motive maybe was to delay. Because if the amicus brief had been admitted by the court, then the court would have also, definitely in accordance with the rules of natural justice, given us the opportunity of filing submissions in response to the same. This is a case where the exercise is supposed to be undertaken next week, and perhaps was just a way of preventing the hearing. And I think the court was justified in dismissing the amicus, the attempt to enter an amicus brief in the matter.
In terms of the interaction the justices had with the lawyer who moved that particular motion, even though the holding was that it was not supported by law, their commentary now is being suggested that the questions of the neutrality had created the impression that to be an amicus you must not have an interest in the matter in terms of direct position on it.
No, but we also ought to, as I just kept emphasizing on candor, the candor of the parties, the amicus itself. It's a matter of public record. It managed stiff resistance to this process. They first started with challenges to the procurement processes and what have you. And when those were defeated, they started arguing the same lines as the NDC. The alleged lack of power in the Electoral Commission to undertake the exercise, and the alleged irregularity or unconstitutionality of the exclusion of the old voter ID card. So really, their position in the matter has been made quite clear and all that. And the very fundamental basis of an amicus is that the person is a friend of the court, a neutral person, usually, a neutral person who seeks to bring some important matter of law and some matter of fact or value to the attention of the court. But where the person has shown his colors clearly as having been opposed to procurement processes, is advocating that one party should have won the bid instead of another, also advocating that the EC does not have the power, and then all of a sudden barges in as an amicus. I think that it shows a lack of bona fide.
So you think neutrality matters in such applications?
Totally, because that is one of the fundamental principles of common law, that the person who is coming is disinterested, and the person is merely interested in advancing either the rule of law or the fundamental principles of law in issuing the matter. And the person also has in his possession some very important issues of law that he or she wants to bring to the attention of the court.
When we interact with ordinary voters, I
think as for the allegations, about the lawyers' lack of preparation, I would not want to comment on it at all. The lawyers' lack of preparation and whatever. It's a matter that I would not want to comment because it involves a professional colleague.
In terms of the bits relating to the voters that have to now turn up to register, there are some who would view that you argued law, but in terms of their rights to it's unfair that through no fault of theirs, they queued to carry out an exercise, they got onto the register. In all your arguments, there was no point that you said that, someone got onto the register through his own actions that he got himself registered. At least an official registered him. And so why must they now bear the brunt of a failure by the AC to obey laws to now go out there in a period of COVID and risk getting infected to carry out the registration?
Right. I think it's the NDC that we must actually castigate as having come to court without any evidence at all. As I said, they threw up evidence, allegations in the air without supporting it at all. The first allegation that they made was that there were voters who were likely to be disenfranchised. It's a court of law, court of record, and not a court of public opinion. You're supposed to buttress with an allegation. Now, I had gone to a extent of showing statistics from the Statistical Service, the National Identification Authority, as well as the Electoral Commission itself, showing 2 points. Number one, that the voters register has been flawed since time immemorial. Voters register was flawed in its preparation in 1995 in the sense that there was no proof of eligibility. And they put out of that proof, they put out of that process, which was no without any.
Right, so that's Godfred Dame speaking with Joseph Akable, talking about the current register being flawed. That'll be all from us this evening on Upfront on Joynews channel. My name is Winston Amobat. Gifty and up here standing by with Joynews Prime.
Certainly, we'll be coming to you shortly with the very latest on this. We'll tell you what the Electoral Commission is saying. They say they're all set to go ahead next week. We'll bring you that shortly on Joynews Prime.